I'm starting the meeting today because the first item on the agenda following the recent AGM is the election of a chair of the committee. Do I have any nominations for chair, please? Richard Stowe. Richard Stowe, seconded. Any other nominations? Thank you very much, Richard. You are duly elected chair of the Standards Committee once again. Thank you.
Thank you. And the next item is the appointment of vice chair. Any nominations?
Peter Easy.
Seconded. Any other nominations? Right, I confirm. Thank you. Peter reappointed as vice chair. Item 3. Apologies for absence. No apologies. Interest at this stage. So we move on to the minutes of the previous meeting on the 6th of February. Do you have any queries on these? Any requests for amendments? So are we okay to approve the minutes? You okay? Yeah, everyone? Okay, so we've approved the minutes of the 6th of February. I'll just go through a few actions from there that aren't covered later. The National will send you the minutes of the National Forum of Standards Committees, which took place on 27th of January. I did send that out on the 4th of March. The National Forum meeting notes and also the Ombudsman's presentation notes from that meeting. Also something else I did send out, we anticipated there would be a full public consultation on the Penn report, and I sent out a link to the consultation document on the 6th of April. And finally, I said I would go back to Michelle Morris, the Ombudsman, to ask on the breaches and non-attendance of training. I did realise quite late that I hadn't sent you the response. So I sent this out on email on Saturday. Sorry it was so late. It's a PDF file. And you'll see there was a short email from me on 10th of April asking, in particular, quantifying the relationship. Is it true for all councils? Does it vary across code breaches or anything? And unfortunately, the response I got, which is there, is data free, basically. I really expected of the 9 referrals, 6 of those cases, there was non-attendance at training or something like that. So didn't quite get what we asked for. One thing was interesting at the end there was she seems to be saying that One Voice Wales are willing to release data about town and community councils take-up of training, which is the online training modules. And so I think I will try that and see if they're willing to give us data. What did Monmouthshire town and community councils do over the last year in terms of taking up those code of conduct modules, which would just be an interesting number. And I would ask them, or did they all do some, and how did that work, basically? So it's worth a go, isn't it? So that's the minutes of the previous meeting, and then linked to that, and an action from the previous meeting was we had a very long discussion on gifts and hospitality policy, and there was an action then on officers to prepare a gifts and hospitality document which would cover all the main issues that we'd raised on the 6th of February for discussion by us and then approval, and then it will have to go to full council at a later date. Paper, please.
Thanks, Chair. Yeah, and out with that conversation that took place at the last meeting, that there's been a wider conversation in terms of, between Welsh Government and the monitoring officer groups across Wales as to whether this, and I think there's probably overlap that the work that's been done around the Penn report, which we'll come on to in a minute, and then just the work that Welsh Government's been trying to coordinate in terms of consolidating and coordinating all of the statutory guidance that falls out of a number of areas of not setting standards. A lot of the changes that were brought in by the Local Government Elections Act 2021. So there was an exchange specifically about gifts and hospitality as to whether it's something that Welsh Government should legislate for, or whether there's actually just a softer way of achieving this, which is can some sort of unanimity of approach be found across the local authorities. And I think that was a discussion at the National Standards Chairs Forum as well, but obviously Richard, you were at that rather than me. So what we've got here is, in order to make any change to what we currently have written with regards to it would require an addition to the Code of Conduct as it's set out in the Constitution. I just stressed the addition to piece there because the Model Code of Conduct, which was first released in 2008 by the Welsh Government and then amended in 2016, we have to take in its entirety, as do all councils. But you do have the ability to make local additions to that, and that's what we're discussing here. So there's nothing specific that we're looking to remove from that piece of legislation. We're just looking to add to it. In order to make that change, because the Code of Conduct sits within the Constitution, it requires a constitution. Why you've got a council and effectively the request of the meeting today is for views and comments on the nature of how the draft amendments are being put forward in order to be taken into council, with the intention that it goes into council on the 20th of July. I think I don't really want to take you too far into the detail of what's written, but it's set out within Appendix 1, and it's effectively taken the existing references under, I think, sections 36.2 and 17, and just growing that 17 the biggest change is the specificity of a sum, which was the key thing that was lacking before, and that's £25. And that £25 comes from, again, the conversation, I think, with your peers, Chair, but certainly with monitoring officers across Wales. So Appendix 1 is the proposal for your consideration.
Thank you. So, members, the details of our discussion last time, the key points are all captured in the minutes of the February meeting. And do you have any questions or comments about the document and the code amendments in terms of meeting requirements last time, or any wider questions or issues that this raises? No, are you happy with this as it's written down? I mean, I
think it's clear.
I think it's clear, yeah. If I think some of the key things that we wanted last time, we thought we needed a monetary value, so we've got that. We wanted to have the registration or of either accepting or declining gift practice. And that's also mentioned in the Ombudsman's guidance as well. So that's there. It also references the Bribery Act, which I think is good practice. And that leads to another question, a linked thing I have, which is the training for elected members on this. Or the other question is, how do we make sure that this, in very simple terms, gets inside the heads of elected members? You know, actually, there's two questions. One is acceptance. Can I accept this? And the second is registration. And the registration rules, quite basically, you don't have to register it over £25. You have to register it whether you accept it or not. But the acceptance issue is always a judgment call, and that's now very clear in 17, 18 and 19. Because it says in 18, whatever the value of the gift or the benefit, if its acceptance may place them under an improper obligation or may reasonably appear to do so, it should always be refused. So I think that's very clear. So that's, as you said, very context dependent, you know, in terms of what's your role, your accepting anything from someone. connected with that in the run up to that determination would be appropriate. However, in another context, when there's nothing going on between the person, the donor, and you and your role, more than accepting a meal out may have no issues, or a day at the races, which I think was the last thing on the Monmouthshire Register. So I think that's very clearly written. And just my outstanding question then is, how do we ensure that this gets through to the elected members? Is it worth them? Do they get in? Is it training? Is it online? Is it sort of, what's the method? Given your council agendas can be very full, how do we avoid this just getting lost? And it's a constitutional change, and so.
So it will be, my intention would be I will brief Councillor Angela Sandals, who's the cabinet member responsible for governance. We have fortnightly one-to-one sessions, so I can make sure that she's aware of the work anyway, but I'll make sure that she's fully aware of the outcome and the recommendation of Standards Committee.
Yeah.
So it'll be Councillor Sandals who makes the presentation to council. Two meetings after I took an annual review of the Constitution in for changes, which had a number of talking points in the run up to it, and indeed in the meeting itself. So it will probably draw the eye that this is specifically going in as a single item agenda. And I suppose I can look to Councillor Bromfield as well as being a member of Standards Committee who will be present in council to potentially speak to it as well. And that might be something we can coordinate with Councillor Sandals. Thumbs up from Councillor Bromfield, thank you. And then it's a case of wrapping it into the code of conduct training that I do to make sure that there's specific reference to this element, because we quite often spend quite a lot of time in the personal interest space, but probably less so in gifts and hospitality. So it's probably it's probably one of those things that once you get into that conversation in those training sessions, we'll draw it out.
Yeah, I
can certainly follow up, obviously with an email as well, or even preempt it with an all councillor email leading us into council, and in terms of my interactions with the group leaders as well.
Yes, I think that would be good. Yeah, to go through the group leaders as well.
Yeah,
yeah. And also, I noticed only by chance that the online availability of the register has just appeared. I just happened to be looking at a councillor profile. I thought after the last meeting, there it is. So worth making sure everyone's noticed that that's actually happened, because I just spotted it, and so now you're under the spotlight. And actually, the registration rule is strict. Anything over £25, whether accepted or refused, must be registered and be in the public domain. So there is the transparency, which is back to your question before the meeting. So anything? Do you have any other comments or queries?
Can I just raise it? It's maybe off the point, but point 18 refers to whatever the value of the gift, hospitality or other benefit offered to a member or employee. So all of a sudden we've got employees coming into this. Are they?
No. You're right. Actually, employees should go, shouldn't it? Because it's the member. It's the member code of conduct.
Members.
It's the member code of conduct.
It's a member code of conduct. Or are you scooping up all Monmouthshire County Council employees into this?
No, because it's going to the code for members. Right. So
that is a typo, but it does draw attention to the fact there is a specific section regarding employees within the employee code of conduct when it comes to gifts and hospitality as well, but that is discrete from this matter.
So that needs to be deleted, or employee gets deleted. Yeah, thanks.
And did you mention that you would speak to the group leaders independently of the council meeting?
Yeah. I think the sequencing would be with the individual profiles to draw attention to that, in line with the fact that the report is coming forward. That then, through group leaders, then turns into a group discussion for them in the build up to the relevant council meeting. then with the cabinet members speaking to it in the meeting, and if Councillor Bromfield wishes to as well, I think that's probably the flow to getting the escalation right to that point in council.
So it'll have at least 3 mentions then if you're going to send out an email, a councillor-wide email as well.
Yeah.
So there's 3 opportunities for people to pick up the information.
Meetings as well, yeah.
Just on the subject of employee, the sentence before it does say benefits by members and officers.
It's the same thing. Yeah.
Officers are employees, aren't they?
Yeah,
Yeah.
and it's the same in 19 as well. Employees needs to go.
Yeah. Yeah. Officers, yeah. Just regarding, and again, a simplistic explanation of the Bribery Act, even though it's probably unlikely it can get an explanation of what that's about will get members' attention. In the sense that I've seen other codes where actually it's put in explicitly, it's in the code, it's actually in the member code of conduct. Because if we're putting this in, we're going to have to say, must not contravene the provisions of the Bribery Act. Well, simplistically then, we're going to need a paragraph saying that's what this is about.
So there's a parallel piece of work here. We're currently implementing a new learning management system, which will contain the training records, and this will be employed. With that duality of trying to understand where we point some of this stuff when it comes to counsellors. It's the same in a different sense from kind of HR support sense as well, access to counselling and what it might be. So there's definitely the bribery, the anti-bribery and corruption training, ABC training, is a fundamental feature of that, and that is something that will be made available to councillors.
Okay, and does that come? Is the lead for that? Does that belong with governance and audit? I was thinking, where would that live?
Yeah, ABC sits with internal audit, and so yeah, it's multifaceted. It's obviously and kind of training space, which could be standards or, you know, with my other hat on in MCC terms.
So should we let internal audit know this is coming then?
Yeah,
that'd be another, you know, and they should then feed it into the governance and audit system.
And conveniently, I've established a governance working group last month, which will be meeting for the second time now, I think next week.
Okay.
Which is actually looking to bring a lot of these governance functions together, because there's I'm the one with the word governance in my job title, but of course there's a lot that sits in the financial space. But then yeah, we're just growing that interaction between key governance representatives across the organisation.
Yeah. Okay, thanks. Anything else on this item? So this, with the amendments, then will go to council on the 20th of July.
Yeah.
Is that right? Yeah. For approval. It has to be approved because it's a constitution change.
Correct.
Yeah. Thanks. The next item is the consultation on the PEN recommendations. This last meeting, it slipped a bit, but it started on the 24th of March, and the deadline for responses is the 23rd of June. So we have the opportunity, if we want to respond to some or all of the consultation questions. So there's 2 documents attached. One is the Welsh Government consultation document, which I sent the link out to in April, and plus there is a paper written by Matt. So I say the response deadline is the 23rd of June, which is 1 week on Friday, and the aim is to look at the general, which is the first half of their document, and then there are 21 consultation questions in the second half. So first of all, if I could ask you, Matt, to go through your paper, then we'll take any questions or comments on that, and then to walk through the individual questions and decide do we have strong views? Do we want to respond, or do we want to move on to the next one? And that will form the basis of a response for a week on Friday.
Lovely, thank you. Yes, we've lived with this for two and a quarter.
Very long time
since the announcement was first made by the Welsh Minister. And so the ethical standards framework, the ESF, I think being used as a shorthand to try and encapsulate, the vast majority of what a standards committee is responsible for, I suppose, but in legal terms. But it does step us into other places to a degree in terms of where Richard Penn went with his work. Just as a reminder, so Richard Penn, former local authority chief executive, carried out, just harking back to previous conversations we've had in standards committee, I think it was noted that there was quite a lot of the report was conducted in terms of interviews, certainly with monitoring officers, but a lot of Welsh Government officials, but I think it is probably previously been expressed here, Chair, not so much interaction with standards committees, although there was certainly some chairs were spoken to, but probably more importantly, councillors themselves who are subject to the Code of Conduct, or complainants who have made use of it. So, although there was a lot of very good work and a lot of very sensible recommendations, it always travelled with that slight problem. You can see within the report that within my report, that the report came out in July 2021, and then I think it's fair to say in the just shy of 2 years hence, this committee's been quite actively involved in how the actions and recommendations from that report have evolved, both in terms of me taking a kind of feel and instruction and direction and actions from here. Honestly, I have a number of meetings with Welsh Government officers directly, and obviously correspondence from yourself, Chair, as well, to those same Welsh Government officials. The evolution of that process has seen some of probably the one recommendation which was the biggest concern, both to monitoring officers and certainly this standards committee, was the recommendation that there be a kind of mandated initial local resolution process before a complaint could go through to the Ombudsman. So, and just as a reminder, the issue with that, I think that probably kind of proud and confident in the ESF as it is in Wales comparative to England as the most obvious comparator, because we do have an independent Ombudsman who is there to deal with investigations and apply a public interest test in a way that, so in the England style of things where monitoring officers will be carrying out the investigations, it becomes a lot more muddy because there is that concern potentially from members of the public that a monitoring officer is not independent because they are investigating councillors with whom they work, but then equally from councillors, it might be an agenda or there might be a personality clash, and it makes it incredibly difficult, both for the monitoring officer, but for just in terms of the public interest in how it should work. So the idea that would have been implemented was problematic in Wales, and grateful to Welsh Government for listening to that, and we can see that is not part of this consultation because it is one of those recommendations that will be taken forward. You can see the recommendations set out there's the link to the report, and then the consultation makes reference to them as well. What we just try to do at the table is to highlight those where there's basically no further action, no proposal to take forward, and it's really the ones where I've highlighted that views are being sought. There's variations on that, but certainly views being sought is predominantly where the consultation focuses on. Then that's what questions. And I don't particularly intend on going into. I'm not going to line by line that table, given that obviously members have it. But that's just how I've sought to filter from the initial recommendations where Welsh Government is potentially going to take action, to then that's why they're consulting, and that's how it strips down to those consultation questions. So I'll stop there before we go into the questions themselves for any comments, Chair.
Can I ask where you're seeking your views from?
So the seeking views is what Welsh Government recommendation report is highlighting where that's what their stated position is within their consultation document.
I thought it was your intention to seek views.
Well, I am interested. Well, sorry, it's not for me to be interested in the Standards Committee's views. It's for the Standards Committee to make a decision on whether you wish to make a contribution to the consultation.
Yes, so what we're going to go on to is at the back of the Welsh Government document, which unfortunately doesn't have page numbers, but if you're reading it in PDF or Adobe Viewer from page 29 onwards, there's the 21 consultation questions. Or not, whether we want to respond or not to each of the questions, and then that'll be submitted. If we do make a response, that will go in before the deadline. Yes, Matt, so I'm very pleased that recommendation 8 didn't make it. Thank goodness for that, because that would have been a completely retrograde step, and as we said in our letter, without any supporting evidence, a step towards the failing English system, and the implications for the independence of the process are very severe, as I know from being in that process. They get politicised. You don't have to think of it. You can just think of examples. Complaints against cabinet members in the administration. How is that going to be handled when the final decision maker is the monitoring officer, and there is no independent decision making whatsoever? So it's tricky, and I think the other side of it is there's a very good system now. So if it's working, let's keep it. And the other side is the confidence of complainants to come forward if they know they've got an independent body to go to, rather than thinking an authority is marking its own homework. So I was very, very pleased with that. If we could have a look at the consultation questions, and the ones that I found particularly difficult were questions 2 to 11, which are all about the adjudication. About half of the consultation questions are about new powers for the adjudication panel. So, Matt, could you walk us through the questions and just say, what does this change mean? In particular, the adjudication panel questions. What does it mean for the respondent councillors? How does that compare to other parts of the justice or the tribunal system? And is what they're asking for? We can decide whether to respond. Some questions just say we don't have a strong view, we can skip them.
So a reminder that the way our process works is, if a complaint is made, the complaint is made to the Ombudsman, and the Ombudsman then has to make a decision as to whether to investigate. And it makes that decision on the basis of, is there prima facie, well, first of all, was someone acting as a counsellor? Is there prima facie evidence of an actual breach? Thirdly, and the key threshold is there public interest? An investigation is then carried out. There are a number of things that can happen with it. It can simply be stopped. To the adjudication panel for Wales. The differentiation between whether it goes to a standards committee and the adjudication panel for Wales is largely in the same way as the difference between a magistrate and a Crown Court. It's the powers of censure. So a standards committee, if it carries out a hearing of someone who's had a complaint made against them, has powers of suspension from being a councillor for up to 6 months. The adjudication panel of Wales has the ability to disqualify someone from being a councillor for up to 5 years. So it comes down to the seriousness of investigations, whether it goes one way or another. Standards committees, and it's been a long time since our standards committee has dealt with a hearing, actually, and of all the standards committee's responsibility for all of the proactive measures, such as these meetings, recommendations of changes to the constitution and the like, the most important, in my opinion, function of a standards committee is that reactive one, which is sitting as a tribunal hearing the case of a councillor. I'm grateful that it's a long time since this standards committee. And the outcome from that is still build up to an adjudication panel. So if we were to ever hold that process here, my default position we would do it in a similar way to how we're holding the meeting today. It would be an open meeting that members of the public have access to. There might be elements which fall under the Local Government Act 1972 of exempt information which shouldn't be made public. That would potentially pertain to specific commercial data or something of that nature, but the intention would be to hold it in an open forum. The adjudication panel is established and procedural rules that it needs to abide by, and so the presumption is that it would be held in public, that press would have access, and it's effectively, I mean, the one that I've been to was held in a magistrate's court, and it has that appearance of a properly constituted tribunal, and I think the chair of any tribunal always has to have had legal training as well, less so perhaps for the other panel members. So these are really stepping us into that space about how should that adjudication panel sit and conduct itself, where the comparison for me is how do things happen in a court of law and other tribunals, for example, an employment tribunal. That's the kind of space I think that we're playing in here, and that's the kind of legislative change I think Welsh Government would have to make in order to achieve some of these recommendations. So hopefully that kind of explains where we are contextually. So question 2 is about restricted reporting orders. Now this is a power that courts have, and it's time, for example, I suppose in youth courts, where you wouldn't expect the name of any child involved in a legal criminal matter in youth court. So there is a reporting restriction in place. In the family courts, actually, I suppose there's a comparison here in that family courts have always had these restrictions on them, but they're slowly moving in the direction of allowing press access and limited ability to report on them. So there's 2 comparators there. But yeah, what's being talked about here is the question 2 is should the APW be able to issue those restricted reporting? I'll stop on the reporting bit before I go to witnesses, I think.
Yeah. And as you mentioned before, there is in the other courts and tribunals, there's a very high threshold for this restricted reporting. You can see it makes sense. Children, family court, vulnerable people, but the adjudication panel is dealing with, it's a civil tribunal, is that right? And it's dealing with code breaches. So what are the circumstances on which you'd want to stop the reporting of information about a code of conduct breach, given what we know what's in what the circumstances be? What is that power? I can understand perfectly for sensitive issues, children, family courts, those things. Why should they be able to stop the reporting of a panel hearing on a code breach, an alleged code breach?
I'm going to, if you don't mind, because Ben Davis, Deputy Monitoring Officer, is our litigation lawyer as well.
Yeah.
So Ben, you're in and out of court on a kind of weekly basis, aren't you?
Yeah.
So dealing with, that might be trading standards matters, licensing, whatever it might be. How often do you see reporting restrictions on those?
Well, I never see them on the matters I deal with in the magistrates court or the Crown Court. As Matt has already alluded to, in the family court, it's always been a private court, or the public aren't allowed to attend. However, that's changing. That's the same with the Court of Protection as well. The Court of Protection has always been a private hearing, a closed hearing, but it's opening up as well in certain circumstances. But in terms of the magistrates and Crown Court, I haven't seen, with the issues I deal with, because they wouldn't involve children and very, very serious offences and so on. But I haven't seen reporting restrictions. The only thing I can think of in terms of the adjudication panel was if breach itself relates to perhaps more sensitive information. That's the circumstance I can think of, but other than that, I think you're in public life, and the panel would hear things in public.
Yeah. Can they be challenged, their reporting order? How does that work?
Oh, you're taking me back to criminal court matters a long time ago from the Crown Court, but yes, there would be. It would be one of those things that I would expect a kind of a little mini hearing within a hearing to stand up, to be discussed. But technical areas of law they're certainly not. They're not common, are they, Ben?
No, in a pre-trial review form that you get in the magistrate's court, you tick whether there are any issues in terms of witness attendance and so on, and that's where it may become a hearing within a hearing if there's an issue on reporting restrictions, and the magistrates or the district judge, whoever's dealing with, have to give a ruling, I would imagine.
So, given that the adjudication panel is a specialist tribunal that deals with it's a very narrow area, isn't it? It's simply breaches of this code, alleged breaches of this code. I can't see any justification for them having the power to. I don't see the evidence for it in the consultation document, and I just can't see it being. I can't see justification, and it goes against the openness, which is back to all the Nolan principles, the openness and the accountability, and it goes back to the open justice principle, doesn't it? And which is part of open justice is the press can freely report on cases, and it seems that to outweigh that, they haven't provided any evidence in here. I see no evidence. And the right to a fair trial, Article 6.1, everyone has the right to a public hearing, which is meant to be a guarantee of procedural fairness. Because actually, if things are reported on, then that will reduce the likelihood of invalid or inaccurate evidence or inaccurate witness statements, etc., etc. And there's tons of case law on that, actually, under human rights, where it's been challenged.
I mean, your question to me was in what circumstances would this be used? I don't know. I can't really provide. It probably goes to your point, and it simply says to impose an order until the end of proceedings would be, or even an extended restricted, or which I assume would go beyond the completion of proceedings, would be appropriate for tribunals where the fairness of the tribunal or the safety of witnesses, panel members, or staff are potentially compromised.
I just don't get it really. If it's, we're not going to have anything involving children in a conduct breach. We're not going to have national security issues. I don't see any evidence to support this, and it's completely contrary to the principle of open justice and the Nolan principles of openness and accountability. Does any of the members, do you think that's, I'm worried that giving them a power, they're asking for this because they want to use it, and I think we should be, as independent members in particular, pushing for an open system where people are held to account, and all we're dealing with is breaches of, it's a very narrow field, it's breaches of this code, that's it. It's not criminal offences, it's nothing to do with children.
Think it through. If a councillor had stepped right over the line and it became a criminal investigation, the criminal investigation would have to be concluded before the adjudication panel sat, because it can't interfere with a criminal process. So even if the councillor had breached it with regard to any criminal matter, whether that be a child or a finance or whatever, that has to be concluded before it goes to the adjudication panel. The report told us is open. I mean, if Councillor Bloggs is found in court for financial irregularities, then the South Wales Argus and the Western Mail are going to be all over it. and it's going to be widely reported.
There is the potential for it to be
Yes.
widely reported. So
So by the time it got to the Adjudication Panel of Wales, one would have thought
in the public domain.
it was already in the public domain.
Yeah.
I'm struggling to see on what circumstances they would ask for reporting restrictions.
Certain another body, so the council from which the councillor is drawn, may have some, as Matt was referencing back, commercial or security information going on, which is somehow bound up with the complaint. So the power to impose reporting restrictions, I'm wondering whether that could be from a government request, from a council administration. As soon as I see the word reporting restrictions, I'm like Richard and I think, no, 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 no. But when I go listening to everyone and diving deeper, I do wonder if it's there for the most extreme of circumstances that we probably can't foresee at present time.
But you have to set that bar. You have to use the word extreme, or somebody has to make that judgment then, doesn't it? I mean, if it's just there, then it can be jumped over at a very low bar. That's the
scratching around the back of the whole issue to see if I could find any different.
To widen it out, this is a Welsh Government response. Now, presumably the Welsh Government have gone to the President of the Welsh Tribunals to ask him, it's a him now, of his views of this, because he is responsible for the Adjudication Panel of Wales. He's newly appointed, it's Gary Higginbottom. He is Welsh, he's coming to Wales as the new President of the Welsh Tribunals. Sees all the devolved tribunals, which the Adjudication Panel of Wales is one. Has he been asked for his views? Because surely he must have a view on whether his tribunals have reporting restrictions or not.
See, I omitted to mention, I was going to say, when I spoke to the report initially, there is, I am vaguely aware of some piece of work that Welsh Government have discussed in terms of status and standardisation. Actually, that's my word. I don't know the standardisation of tribunals. Woefully read into that, so I can't advise you properly in any way, and I don't know the answer to that question.
Yeah, that I mean, I know from another, forum that I belong to that is going on. It's looking to see if it can mirror the systems of chambers that they have for tribunals in England. But that is the province of the President of the Wales Tribunals, as far as I see it. And he sits over, I mean, I've just looked at, in fact, the last President of the Wales Tribunal annual report, which is 2018. So and he has least tribunals that he oversees. The Welsh tribunals would have a view on this, and should be. Maybe that's where we need to say in the consultation. We would think that the President of the Welsh Tribunals should have a view on this and should be the ultimate authority of whether reporting restrictions are permitted.
No, you made a really good point, actually, and actually that should have happened before we, as a standards committee, get these questions. All 10 of the APW powers questions
should be addressed to him.
There should be. We need actually a document, a written response to say their view. How does that fit? And what you're referring to, Matt, something that I'd spotted. It hasn't really seemed to have got off the ground. But I'll show you this, Rhiannon. This is a thing that's something that I was vaguely aware was going on in the background. Is there are plans to do this unification
Yes.
of all the Welsh tribunals under a single first tier tribunal with like branches. So the presumably will be a branch called Council of Conduct and the branch called, I don't know, Mental Health or whatever, all the way along. And there's going to be an appeal tribunal above them.
Yeah.
So the appeal route, I'm guessing it won't be High Court anymore. It'll go
to the
first tier
minister.
tribunal to appeal tribunal. Speculation, and that's why I mentioned that, saying running this consultation on new powers now, when clearly they're about to kick off unification, and more importantly, Rhiann's point, there is a brand new president of the Wales tribunals who should have a view. That could be our response to all the APW questions in it, and added to the fact that I don't think they've produced any evidence to support the requirement for restricted reporting orders, and we'll come on to the anonymity of witnesses as well. But the bigger issue is we need more information in front of us, perhaps to make it more responsible.
This document here,
Yeah.
just on my scan
Yeah.
reading of it, I am familiar with this,
Yeah.
and I hesitate to say that they're implementing the English system because Wales would never do that.
No.
But they are considering using a system that is not dissimilar to the unified tribunal system that is in Wales, with an appeal process. Because at the minute, all Welsh tribunals appeals, I believe, have to go into the High Court.
Yeah.
Whereas in England, they go to the administrative court.
Yeah.
And then they go onwards. So there's an opportunity for it to stay within the tribunal system of
That's right, yeah.
review.
Yeah.
So, yeah, I mean, I think, this article refers to Sir Wyn Williams. Well, he is now retired, and Gary Higginbottom is now the president of the Welsh tribunals. So, I think you're right, Richard, that with so much change being proposed, and the new president in place, I would think it was more important for him to have a view on this that we could then comment on.
Yeah. So could we send that?
Could I capture that then as initially against the idea under the principles that you outlined in terms of access to justice, Article 6.1, etc., etc. However, minded that given that review, given that you have a person in that position, and the lack of information that supports this recommendation, we would want those steps to be gone through first.
Yeah, definitely. I think it's a caveat that covers on them.
Okay.
Two things. One is the Rhiann point about we need to see really the views of the new president of the Wales tribunals, and the second thing is to understand how this fits in with this announcement. Now, I did check there, so that was like a ministerial announcement about we're going to move towards the single unified tribunal system for Wales, and all I could find when I tracked back was that comes from a Law Commission recommendation from December 21. But when I looked yesterday on open consultations, there are no on the Welsh Government website consultation on this, but clearly it's coming because that's what that says. It's just the same as Penn. We had the notice that a consultation is coming, and at some point it will start. So if that's about to start and make these changes, I can clearly the appeal procedure is going to change from APW to High Court to first tier tribunal branch APW to appeal tribunal. Then there's questions in here about changing appeal procedures, for example, in our consultation document. So there's a possibility of us actually wasting our time, not acting on having all the full information and getting a lot of crossed lines.
The press release refer to the 4th annual report of the president of the Welsh tribunals. So he's clearly done them annually, but on the website of the Welsh Government, they've only got the 2019 report. So it may be helpful. Maybe this consultation has come out of that 4th report, which was written by Sir Wyn Williams. And I'm sure Gary Higginbottom, I think he's a Sir, Gary Higginbottom will be taking that forward.
Yeah.
So we may want to try and access, just out of curiosity, if nothing else, what the 4th annual report does. and it's the Counsel General who's announced the consultation, so
Yeah.
he would have had to receive that report from the President of the
Yeah,
Welsh Tribunals.
yeah, exactly. Yeah, yeah.
Um,
yes, and that's just you. That's the
Oh, that's
background.
the
background that I
background,
found. So could we have those in our response to this? Is those the two caveats? One, how does this cut across the unification of the tribunals, which we know is going ahead? And two, it would be invaluable, or we need to see a written response from the new president of the Welsh tribunals regarding all 10 questions. But we could still objections, like I have to question 2. I think we should submit them anyway, because I still think there's that argument about it. I don't see in what they provided here the evidence to support messing with the open justice principle and Article 6.1 of the European Convention, etc. And also with the press reporting, it also relates to Article 10 and freedom of expression as well.
It may be helpful that the public announcement of it is Sir Gary Higginbotham. The Counsel General does say it is appointment in May 2023 on the Welsh Government website. This is a crucial time for tribunal to create a simpler and more coherent system, which indicates this. And I know under Sir Gary Higginbotham's leadership and expertise will be vital in continuing to strengthen the role of devolved tribunals. So he clearly sees him as a key player in this.
Yeah. Okay, so we've got 2 caveats to all of those 10 questions. Can we carry on then with question 2, with question 3 on anonymity?
Yeah, should there be expression to protect the anonymity of witnesses? So again, I suppose if the APW thinking is that standardisation of those tribunals, then this is something that is permitted in other courts, and clearly something that they don't have the power to do at the moment. Thoughts?
Yeah, but because of the document, we don't know whether that's the argument. It just looks like the it's reducing openness, and it goes against the open justice principle before the meeting started. When I started looking at some of the case law about this, in cases involving national security, witness anonymity has been refused by judges, even where the claim on behalf of the witnesses was our personal security really is at stake because it's to do with terrorism issues. So we're not going to be dealing with things like that at the adjudication panel again. And so I don't feel that adequate evidence has been provided. And so in other words, there needs to be a big weight of evidence to outweigh the presumption is that open justice, which is considered a constitutional principle, isn't it? So you need a very heavy, that's my understanding. And then in addition, you throw in the mix Article 6.1 and Article 10 of the European Convention. So you've got all of this stuff saying everything's open, justice must be done and seen to be done. So when you want anonymity, you've got a high threshold. Is that correct?
Yes.
Yeah. So, and I don't see, well, there's nothing in the Welsh Government document that persuades me that there is a requirement for that, given the narrow range of functions that the adjudication panel carries out, which is purely breaches of this code. Should you have declared an interest? Did you bully and harass? Did you misuse your authority's property? No? Do you really need anonymity of witnesses? I can't see it at all. Any comments on that? Can you?
I'm struggling to see why you would.
Yeah.
I mean, if you've come forward to be the witness, then you've already made that decision, haven't you? I'm going to be. I mean,
it is concerning because we see it happening now across various areas of public life. For example, the Plaid Cymru recent issue that forward complaints. I don't mean that they're anonymised to the alleged perpetrators, but they are being accepted as complaints, but nobody's actually putting their name to them. And this principle seems to be widening across lots of sectors. So my inherent feeling is that we we really have to protect this.
Yeah.
And I'm with
Yeah.
Richard on that totally.
So my understanding that in the consultation, there's no adequate evidence to justify outweighing 6.1 and Articles 10 of the European Convention. That would be my view on this. And it's up to them. And if there is, then it should have been in the document. So it feels like asking for a very heavy-duty power with completely inadequate evidence, given that the evidence you need has got there's a huge threshold here. Because there's there's loads of Supreme Court cases on open justice and the constitutional importance of it as well. And I did find cases, terrorism cases, where anonymity had been refused.
Not working on my laptop. Sorry, I pulled my phone out.
Right.
I'm just trying to remember. I think you can submit a complaint to the Ombudsman to start a process anonymously. But I think because of this, there is some form of warning within their guidances. At some point, you need to switch from anonymity to being made aware in the first instance of the person that you're complaining about. So it raises that question, doesn't it, as well? If you allow this at the end stage, does it impact actually how there's two sides to that, I suppose. For some people, they would welcome the anonymity that would enable people to come forward who are otherwise concerned. But then the other side, of course, would be concerned about the vexatious use of the system.
Yeah.
Especially given, and I think it's right to bear in mind throughout this discussion, we are talking about an ethical standards framework that applies to a political arena.
Yeah. And
the political arena is different in terms of how how a complaint system might be used. I mean, I can't think of any national examples of this at the moment, obviously.
So my view on question 3 is that, again, no adequate evidence has been provided for this additional power to demonstrate that it would outweigh the constitutional principles of open justice and Articles 6.1 and 10 of the European Convention. And put the ball back in their court, because I don't think they have provided adequate evidence. Are you happy with that?
Yes. Yes.
So, Matt, 4, do you support the proposed changes to the permission to appeal procedure? And in fact, so the other questions as well, there's questions on openness. Question 7, an express provision to enable part or all of tribunal hearings to be held in private. Should we just say that all questions about which go against the principle of open justice and the convention rights 6 and 10, there's inadequate evidence. So we oppose them. That would be my view. Given the nature of the material or the of the APW, which is just, it's code breaches, it's fails to declare an interest, it's bullying and harassment, it's lack of respect, it's misuse of council property. I mean, private hearings just doesn't make any sense to me at all. Actually, I'm really struggling with all of the questions to do with reducing openness, increasing secrecy of the proceedings. I don't see any adequate evidence, and that's important given what they've got to overcome, given what's happened elsewhere in the courts. So could we have that as a blanket answer?
Yeah.
We also have to bear in mind that the number of cases that the Adjudication Panel Wales year are less than a handful.
Yeah.
I think 3 last year, wasn't it?
Yeah, something like that. Yeah. And
huge amount of attention on matters that really are,
yes,
their powers are often not used.
So, given what we've said, we could just then make questions And just to say, so we've got those caveats. We've got the thing, A, we need to know how this interacts with the unification of tribunals. B, we want to see written evidence or response to this from the new presidents of the Wales tribunals. And C, for any of the proposals that are to do with reducing openness and going against open justice, we need to see very strong evidence that can outweigh the constitutional principle of open justice and Articles 6 and 10 of the European Convention. That's our answer.
Can I just?
Is that reasonable?
Absolutely.
I'm on you lawyers now to tell me, is that sensible?
Well, it's I don't want to tell the Standards Committee what's sensible.
No, but that's your role.
It's technically entirely appropriate. The questions that you're raising entirely appropriate. The comparators with other tribunals, what is going on in the whole tribunal space?
Yeah.
The principles of bringing in, yes, the Convention on Human Rights is entirely appropriate.
Okay.
And I think there is the subtext is that respecting the fact that this is a political arena, like I just said.
Yeah.
No, necessarily so the tribunals.
Yeah.
And the other element is it's that proportionality scale piece, isn't it? It's 3 cases last year.
Yes, exactly.
The levels of powers we're talking about comparative to some of those much more powerful courts that you made reference to.
Yeah.
Can I just check Standards Committee's consideration of the 9th question, which is about increasing the range of sanctions? Because that probably doesn't get covered by that answer. I know that the Monetary Officer Group's opinion is that, increasing the range or flexibility of sentence is no bad thing. Training being undertaken, for example, because that doesn't exist at the moment. The one I'm never comfortable with, if I'm perfectly honest, is the direction of an apology being given, because I don't really see the value of such a direction or the action that results. And then, of course, what you get is into the combinations of, if you don't attend training within X number of days, then you become suspended for X number of days, and so on and so forth. So I'd just be interested in your views on that.
I think it's quite clear cut at the moment. You know, when it goes to you can be suspended or disqualified. I quite like that. It's the top of the pile. Why they see, as you said, 3 or 4 cases a year. It's only the serious stuff goes from the Ombudsman. The middle ranking breaches go back to standards committees who have less powers. I think if we wanted to be able to suspend for longer periods, or we want to be able to disqualify for longer periods, okay, that's fine. We're getting to this thing of mandating training. I think it should be left as simple and serious. You think, oh, I might just get off with a recommendation for training then, because actually that tells me that case shouldn't have gone to the panel. It should have come to a hearing in front of us. So those powers, if they shouldn't be up there at the top of the tree, if necessary, they should be with standards committees carrying out a hearing, or should be able to mandate training or mandate apologies or something with a trigger that says, and if you don't do it by date X, you're suspended for 6 months or whatever. But once you're in Cumbrian Magistrates Court, for example, if you're found breach, those are the outcomes: disqualification or suspension. And don't muddy the waters, because lower level breaches should come make it to the panel in the whole of Wales. So I'd say I don't support it, and I'd keep it simple.
That would require, is it worth putting in then? You would forget that this question's coming for the APW. It should be considered in the context of the Standards Committee.
I think it might be useful in the Standards Committee situation, because we might find where there's been a breach, but there's some mitigating circumstances, therefore, that we don't want to suspend. However, we think that an apology would be, and to be able to you might decide actually it was a misunderstanding or a misjudgment of a complex area. Let's say personal versus prejudicial interests, where it was a real borderline one, where you could argue, if you're being conservative, declared it. If you're thinking, I'll take a risk, I won't, you went the wrong way, people can look at it differently, therefore. So yes, I think I wouldn't do it with the panel, but I think it could be useful for hearings. Would be my answer on that. Is that okay?
Okay, then, so discussion about the element 12 now.
Yeah.
Raising awareness of the ethical standards framework. I don't know if anyone has any views on that.
Yeah, immediately I'd say making sure that there is media coverage, you know, making it easy for media to cover all APW hearings and all standards committee hearings. It's media coverage, and that's what raises the framework. But actually, there's a process. It's open, it's fair. This is what happened, and there's serious and effective sanctions. And I think it's that story when it hits the BBC Wales page now, or with South Wales Argus. I think raising awareness, you know, the fact, the minutiae of the code and all of that. No, not really. I think it's media and social media coverage of standards committee hearings and APW tribunals and their outcomes. I think that's the best thing. That's what people spot and gets their attention. I think actually that there is a process, and it's, you know, it's open, it's independent, it's got effective sanctions. You know, APW takes place. Whereas the rest, the details of this, that would be my number one thing. Would be improving media coverage, media reporting and coverage of APW hearings and standards committee hearings. Anything else? Is that? I mean, that's why I get people pinging me emails with spot because BBC Wales picks them up, doesn't it? All of these things. Picks up cases. Pembrokeshire Council did this, and
it's the understanding and my addition to what you just said so well, Richard, is that if there are to be very significant changes to this code as a result of all this processing, there should be briefings to explain it all to local democracy reporter.
Oh yeah.
Local.
Yes.
Political editors.
Yeah.
So that the context is set, and then when they come up, it's understood within its
that's brilliant.
home.
Yeah. I think that's a brilliant idea that we should recommend. Does online training briefing for all the local democracy reporters in Wales, and should have a communication path to them, whether it's distribution list or whatever.
That's right.
Yeah, that's it exactly, because they're the people who always write this stuff up, aren't they? Yeah, invariably.
It has been something that has come into play in recent years quite successfully, surprisingly.
Yeah.
It was not forecast to,
Yeah.
but it's doing quite well in helping the intricacies be understood and so valuable.
Yeah. From who, by publishing something, stopped Herefordshire Council concealing proven councillor misconduct when a committee had voted to keep it secret. And it was the press coverage which he wrote, very good press coverage, but it rolled along, and in the end that got overturned. So I think that's a great idea, and I think they would, their organisation, I think it comes out of BBC in Birmingham, they'd really appreciate that as well. So,
if possible, do as much as a face-to-face as would be done geographically.
Yeah, but certainly it's the kick-off. Yeah, on that training. Hearings. There's a press statement from her. So, well, that's our answer to question 12.
Thank you. So I'm going to take the next one as a batch, if that's okay.
Yeah.
So these are about yourselves, effectively independent members. So the first element is whether you agree that because there's a very rigid legal process for how we advertise and recruit. So should the demand or the obligation of advertisements in 2 local newspapers be removed? The next part is independent members, being independent members of their own previous employers committee be removed, and then subsequently the same. What if you do agree with that? What should the period of grace be between leaving that employment and appointment to a standards committee? And then there's another nuance for those who hold politically restricted posts. Just explain those quickly. All employees are bound by a code of conduct. Some employees, like myself, are bound by having politically restricted posts, i.e. we have a greater degree of restriction on us in terms of parties, commentary. So all senior leadership members would, comms teams would, and then various other people who hold certain roles will have additional restrictions on them in terms of that kind of involvement in the political space. And then the same question regarding employees, but for former councillors, whether there should be the lifelong ban continuing on former councillors joining as independent members of the committee of the council that they have left.
Well, as independent members recruited in the system, do you have a view on this?
It seems like a very minor thing in a sense. But I don't quite take the justification for not advertising on local newspapers. One of which is it's costly, which in the general frame of things is ludicrous.
Yeah.
It's not that costly. And I don't understand what council networks are. So seeking independent members through council networks is better than seeking them through public newspapers. I'm a bit suspicious about council networks. Probably shouldn't be, but I just wonder how that would generate a larger and broader field than any member of the public able to read about an advertisement. As I do.
You just can't conceive of it not being open and transparent. It's so fundamental, isn't it? We go to the widest audience we possibly can, and that has to be including the local newspapers.
I mean, it may be in at least 2020. There are other publicly available forms of media other than newspapers that you might want to consider or might be considered.
But it's not stopping you doing other things. So you can still use your council Twitter, Facebook, Instagram, whatever else your social media is. But then what about people in the Stone Age like me, not on social media? So, I'm completely against this. I read the justification. It's just no. I mean, all sorts of other things, highways notices, planning notices, still have to go in papers, don't they? No, absolutely not. Doesn't prevent you as an authority from putting it on your own social media or doing whatever other method, or asking councillors to promote it, to people they know in the community, etc. There's nothing stops you that.
It's a baseline.
It's a guarantee, isn't it, of some degree of openness. Oh, so you only publicise that through your council Facebook page. What about people not on Facebook, etc.?
The other thing, I mean, talking of the Stone Age, but aren't local newspapers available in public libraries? So some people still use public libraries. I think they're well used in Berkshire. So you can access to it there. You don't even have to pay for it. So you're broadening the scope of people who can read and access things. I mean, I think my own application to this committee, which was some years ago now, but what attracted me was your Twitter comment, which then said, we're looking for standing committee members, here's the information, which I then clicked on, and up comes the information. Coincidentally, I also buy my local newspaper every week because I want to support my local newspaper. And I saw it in there as well. So, you know, I had two opportunities to see it. I mean, I don't think we should limit, we should, you know, expand. So social media is excellent for some people, but newspapers are also have a valid point too. And I don't think we should take it away.
No. So we absolutely do not agree that the requirement to advertise in newspapers should be removed.
Can I want to just make sure there's not a misunderstanding here. The requirement being removed. I pick up on the comment that you picked up on, Peter, about council networks. I think what they mean that to be is not like old boys networks and what have you. It's the use of the different channels that we have access to. So for clarity, removing a legal requirement for newspaper notification is probably something that is being pursued in all of those things that you mentioned in terms of highways notices and what have you, because it comes down, it's like any public sector decision at the moment is what's the most effective way of doing something. And we are talking thousands of pounds for paper advertisements. If you're having to commit that money there, you don't have the ability to commit it anywhere else. Whereas hundreds of pounds of boosting through Twitter, Facebook and LinkedIn, because I have the communications department and of course I have responsible for people here, I know what the most effective way of recruiting would be. We do not ever recruit jobs in newspapers. We use all those other methods. So I get the point about it being a minimum standard, but I suppose the question here is why would papers be a minimum standard? Surely the most effective use of resources for recruiting is what's being pushed for here. And that isn't, for all the people who do newspapers, it isn't newspapers. If you want the widest possible reach for potential independent members, and especially, and I think this is probably where Welsh Government's interest is, the diversity and democracy push is not, as a body of work, is not going to be recommending that newspapers are the way of increasing diversity of representation.
No, and I don't think, which are effectively free channels now for the authority through social media and any other, but as a baseline, there are still people out there who buy the Abergavenny Chronicle, like I do, and Hereford Times, and etc., and read newspapers and aren't on social media. And I think, therefore, also on diversity, you shouldn't be cutting them out. So no, but that's the other argument. I'm not saying you shouldn't use social media. Absolutely, we have used social media in the past, haven't we? But
please don't think of social media as free. In terms of the effectiveness of using it and greatest reach, it's not. If you have to commit money to one particular method use boosts and all the kind of algorithmic tools that exist within social media to gain greater reach when we're carrying out recruitment. So it's not a question of the only paid means is through papers and therefore why have that as a bare minimum. It is an opportunity cost.
Excuse me, Chair, can I just interrupt quickly? Councillor Catherine Fuchs has joined us. She's actually replacing Councillor Ben Callard on the committee, but there had been a bit of a mix-up with my error with the invitation. So she's joined the meeting now. Just wanted to introduce.
I've got a real interest in diversity and democracy, but lovely to see you all. I will try and catch up.
Also, Councillor Bromfield's got her hand up to speak.
Oh yes, Councillor Bromfield.
Hi, thank you. Yeah, just wanted to reiterate Matt's point about social media not being free. It can be quite costly. I don't agree that we should take advertisements for independent committee members from newspapers, but another idea would be to utilise through community councils, because a lot of community councils have websites with links to the website. They can put notices up on notice borders, and notice boards, and a lot of people are in touch with their community councils. So another possibly free avenue for doing that could be through community councils, but just an idea.
Exactly. Yeah, that's a good idea as well. And similarly, I think on the last recruitment, we pushed something out through the county councils as well, so they're aware that this is going on. No, it's I personally to put vacancies for independent members in the newspapers, but accept that there are other more efficient means and free means through community councils and through county councillors to get a wider reach. But I don't want to see that requirement removed.
Now, I concur with you, Richard, because with this particular area of work and committee, we are looking at people who are bringing expertise from a huge range of professions or life experience. In my mind, to cut out local newspapers would see that feed substantially impacted.
Yeah.
Others may not agree, but that's the point that I would put on the table.
Yeah.
I don't disagree.
I just want to make sure the understanding is the proposal is not to cut out newspapers, it's to remove an obligation to use them.
The trouble is, if you
Yeah.
remove the
Yeah.
obligation, you won't do it.
I can tell you don't want to do it straight away, just from what you've said.
So, I mean, if you remove an
stop it. So I think
In terms of my personal view, it would depend on what I'm hearing.
No, of course not. But however, we're about proven independence and an open process. And for me, it's a foundation. It's not sufficient. And there are all sorts of social media methods and making use of other groups, as Councillor Bromfield said, the town and community councillor community and county councillors, etc. as well. There's all sorts of other methods, but for me, it's a foundation of openness and independence, and it should be an obligation, because I think if it wasn't an obligation, my sense is monitor officers wouldn't do it. They say it's too expensive, we're not doing it.
All of those routes then?
No, no, absolutely not. I'm open on that. I just don't want a foundation of an open process to be removed, because if the obligation's taken away, it just would disappear completely. That's my view.
I suppose the question I've got is, if you're a resident of Monmouthshire, which newspaper should you be reading? Because I don't actually have a local newspaper, I suppose, where I live. I'm the newest member here. I didn't see an advert. In my last profession, there was a time when you'd open a local newspaper and it would be filled with advertisements for teaching jobs. That doesn't happen anymore. You just don't see them. And the primary reason for that, certainly when I was in Cardiff, was cost. The county council went down the line of having its own newspaper where they started publishing their advertisements, but that didn't go down terribly well, and that was pushed to every letterbox in the city. I'm not sure that it needs to be mandated. I'm sorry. Does it need to be in the London Standard? Does it need to be in the Western Mail? Where do we put the advertisement for someone that lives in Monmouthshire? I'm not sure I know anybody in my village that buys a local newspaper. I'm not sure I know anyone in my village that goes to a library to read a newspaper. We go to libraries, but I don't think they go there to read the newspapers or to look at the job ads. Yes.
Yeah, I was just going to say that, a lot of people do read local newspapers because a lot of people want to support local businesses. So, it works for other things within the council. So I don't really see why it should be taken away. Just because some people don't, for a handful of people that don't, a handful of people will. So that's my view.
And just of all, the cost is, look at, we don't have many recruitment exercises there's 4 of us. We've currently got 1 vacancy. I think since I've been a member, which is we've been through 2 recruitment processes, so we're not talking a significant cost.
Yeah,
You know, that's like teacher adverts, you know, which I appreciate coming up all the time. So
I should just probably answer the question. So it has to be local circulation. So for us, Abergavenny Chronicle, Monmouth Beacon, Chepstow Free Press.
It's the Monmouthshire Beacon.
Monmouthshire
Covers the whole county.
And South Wales Argus. They're predominantly where we would look.
What does that cost?
Oh, but you need quite a lot of space because they have to go bilingually.
Yeah. It's tricky.
So can we conclude that the requirement should not be removed?
Yeah.
Okay, but that says nothing about other methods, obviously. The next 14A and 14B and 15, all about the qualification criteria for what makes you an independent member. And we can never have been a member of Monmouthshire County Council. We can never have been a paid employee, etc. There's no ifs, no buts. You know, if you've been an officer here at any level, that's it. You can't be an independent member of a standards committee, but you could be an independent member of an adjoining authority standards committee like the Park Authority or Torvine or something like that. And so here we are. Do you agree the lifelong ban on former council employees being independent members should be removed? And should there be a grace period? And the same for the lifelong ban. Of course, the lifelong ban doesn't apply to all standards committees. It's only the authority of which you were a member. So Faye, you will never be able to be a member of our standards committee, okay, under the current rules. That's it. But if you wanted to, you could become a member after leaving the authority for 1 year, I think. You could join Torvine or the National Park Authority or whatever. So it doesn't stop you, but it's meant to be pure independence.
I do wonder, well, especially for yourselves, an independent member after you've left an authority, why is there that lifelong ban? I was struggling a bit with these ones because obviously as a previous officer or a previous councillor, you know, living in an area where there is the County Council of Monmouthshire, you know, you do have the best interest at heart for that county. So I did struggle a little bit with these ones, but maybe it's my lack of experience and knowledge. I was just wondering why there is that lifelong ban that even when you're retired, you can't join that standards committee.
It's about a very strict view of independence, in the sense of, therefore, the fairness. If then you come up, there's an allegation about as a councillor and you're in a hearing, then the majority of us on the committee and the chair, the vice chair, are always independent members who have never have objective connections, even historical, with the authority. So for the four of us, you know that we have never been an employee of Monmouthshire County Council and we have never been members of Monmouthshire County Council. So that should give you confidence of it. So, you know, do you think that Matt, you know, should be able to come back and be on this standards committee as an independent member? And my view is absolutely not. You know, no way, nothing personal. But and you know, if you start thinking about senior officers coming back, you know, when they've had relationships and known people. You know, they're insiders, and they're insiders from the historic relationships, but also I think, and again, nothing personal, Matt, but there's a sort of, you know, a worldview of a culture perhaps of the authority that we, 4 of us, we are in this building twice or 3 times a year. We have no connections at all with the authority, and I feel that's a really important guarantee of independence which is of value in fairness, you know?
Yeah.
Fairness, it would be a fair system in the event that we have a hearing and we have to decide has someone breached the code. And that's why in the Local Government Act, all standards committees have to have a majority of independent members which fit the current very strict criteria. You know, no former employees, however long you've been gone for, no former actually, former employee joining Torvine Standards Committee, I think after 1 year, is that right? After 1 year, you'll be eligible to be an independent member on Torvine Standards or on Cardiff or on Brecon Beacons, any other standards. So it doesn't stop you from taking up that role, but it's for public perception. You know, it would be really severely bad, I think, if former councillors at all and former senior officers coming back as so-called independent members. I think once you've been an officer, you can't be independent. I have a very strict view of it. We're appointed on that basis. We wouldn't have been able to apply on the strict basis.
Yeah, okay. Thank you.
So it's about public perception, really. Perception.
Well, and integrity of fairness, isn't it?
Yeah, that's really where it is.
I should probably just add that we have refused applications in the past as well, just so you're aware, because of these rules.
Yeah.
Yes,
Yeah.
we have. I think, I mean, for me, as a citizen of Monmouthshire, I would want to ensure that the standards committee that, you know, is as independent as possible, and no perception of bias. If you start to have a perception of bias, then people just shrug their shoulders and say, oh well, they're all in it together, whether we are or not. But you know, it's that perception, and I think we have to protect that vociferously, in my view.
Do you agree with the strictness makes sense from public perception?
I guess I do agree with it, but I mean, just to give a consideration to periods of grace, which is one of the ways in which it can happen. And I just don't think that, if you believe that a period of grace initiates independence in a person, then you might accept that as an argument. But how long that period of grace would have to be? It would have to be longer than 12 months for a councillor, for sure. It may be a whole electoral cycle or 2 or 3 to get to a point where there's not much point in having it as a rule. So I think the cleanness of the suggestion is probably what we should go for.
Yeah.
If you analogize it, I mean, it's not the same because tribunals have a legal standing, but in tribunals, you have to immediately, if you know any of the parties or witnesses or have any knowledge of the case coming before you. But that's not possible to do in a standards committee because, you know, we're in amongst it. But tribunals are, you know, case specific. But they have to be, you have to recuse yourself. And if you don't, you know, there's serious consequences.
I don't see any case for weakening the very strict criteria for independence, for the independence of us. And I don't agree with what it says in the Welsh Government document about difficulty of recruiting. I just don't agree with that at all. I think there's a huge pool of people out there who would make very good independent members who would be absolutely clean and disconnected from the authority, never been a councillor, never been an officer or an employee at any level. And we should make more effort to reach out and find true independent people. That's the process, and not think this looks like a soft option. Oh, we couldn't find anyone through our recruitment. Let's relax it. To me, and I'm absolutely against it.
I don't really understand why they're asking the question.
No,
I mean, that it's not the question to be asking.
No, it isn't.
In terms of public perception.
I can answer that, I think, thinking to how the Penn report was put together, in that there are standards committees that struggle to recruit independent members. And I think it's purely that.
Yeah.
that lens.
Yeah. So it needs to be more imaginative, better efforts on recruitment and getting the message out there to all sorts of ways, as some of which have been suggested today. So can we say all of those 14A, 14B, 15, we absolutely object to any weakening of the independence criteria for the independent members of standards committees? Very clear. Yeah. 16, Matt, what does that mean? Should we have the power to summon witnesses?
Well, I think this overlaps with how you responded to the APW one, which had the witness summons as well, which is you probably want to be better informed by what some of those changes are happening in the APW space before we get into considering. And then I think 17 you probably answered when you answered the sanctions question about APW, in that they should sit with the standards committee and have that breadth.
Yeah.
And the APW should hold at its level of disqualification or suspension.
Yes, so 17 was that the power to mandate apology or training backed up by, if you don't, there's a suspension coming, could be useful, couldn't it, in cases, yeah.
And then the remaining questions are the standing Welsh language questions, if anyone wanted to draw any of those.
I don't have a view on.
I suppose the point I would make in terms of some of these questions are everything is bilingual to the ombudsman.
Why is it such? I mean, I thought it would be mandatory that everything was in both languages.
It is. I think it's also mandatory that consultations by Welsh Government will always include these questions as well.
Oh, right. Okay. Okay.
Okay. So we leave those then. Anyone's got no strong views, just no response.
Councillor Fuchs has had a hand up for a while.
Sorry.
We can't see your little hand.
We can't see it.
You're gonna have to shout it.
I can't see it. Sorry.
Oh, that's strange. We can see it, can't we? Don't worry, I was just waiting patiently. But thank you, Councillor Bromfield. No, I just wanted to agree about the going back a step to the no weakening of the rule around if you've stood as a councillor or you've worked as a council employee, because I do think that would that could cause problems if people already have a relationship, and much better to have a distance. So I just wanted to agree with that. We could just say no adverse. We don't believe there'd be any adverse effects. Sorry to reopen the newspaper thing, but I guess my thoughts would be, does it have to be mandatory that you put it in the newspaper, or can it be an option that this committee decides at the time? Because it may be, yes, that we you know, if advertising in all those papers is going to cost £3,000, you know, that's £3,000 that could be spent somewhere else. So it feels to me like it's perhaps us as councillors, we're not we're perhaps a little bit more, you know, engaged and want to know what's going on in our communities. But yeah, I kind of take, I almost think you would take each occasion as is needed. You know, in my business, and I'm guessing in Faye's business, when, you know, sometimes you advertise in a newspaper because you think you ain't going to reach enough people, and other times you just do it on social media and word of mouth. So I just think, I don't know if it needs to be mandatory, but I think we need an option there to be able to do it. That was to make that point.
Yes, thank you. I think my sense is that the majority of us believe it should be mandatory, because otherwise it won't happen, and we don't want to see it. It's a foundation of an open process. It means you can do, in addition to that, whatever else you like, but it's something that we believe is still important. And if it wasn't mandatory, my sense is it would largely disappear. So I think that was our view as the independent members. We wouldn't want to see that removed, and I think, well, one of my roles is really to make sure the openness and the independence to really stand up for it, because although we're a majority, of course, we do have county councillor members, we've got community councillor members as well. And so we're representing in the independence and the openness of the process, which we don't recruit. We've done 2 recruitment processes in over 6 years. That gives you an idea of the cost, okay? So it's not a recurring thing. And we think it is an important foundation of an open system, and it shouldn't be taken away, is the view. But
Okay, I'm happy to go with that. That's fine.
All the creative methods, from the phase suggestion to social media to all of the methods, wide open, and we can decide, and we do decide on how else we're going to reach out to the largest population of people who meet the criteria, and we should always do that. But I don't want to remove it, because I sense, you know, from a financial point of view and a cost issue, there'd be pressure or that it would disappear. But given that frequency of recruitment cycle, because once you recruit an independent member, they're on a 6-year term, which is then renewable for 4. So once you're in the system, like I'm 6 years in, I've just had, which you may remember, you all voted for me to have another 4 years. Thank you very much. So, you know, once you're in, and after 10, you're gone. There's no debate. Again, it's very black and white, and I like the black and white nature of it. It's clear to explain, it's robustly independent. And perhaps another reason why to not water down the criteria, because when you recruit long term, I'll watch out for your hand in future. Thank you.
Having thought about it, given the sort of responsibility that this committee could have, the expense every now and again is almost justified to make sure that the committee does remain impartial and can be seen to be outside the system. It's not that great a cost for.
Yeah, exactly. Do AOB question 21? I think we've exhausted this, really, have we?
I think, Chair, the committee can be quite content with the fact that the work that it did between the report release, the follow-up conversations that you've been involved in, the correspondence, and the removal of recommendation 8 regarding the intermediary step, local resolution, it probably means that anything that might have got an AOB has actually has been achieved. In fairness.
Yeah. Good. So Matt, just on the response to the Welsh Government, could you draft that and I can check it and read out from the 21st onwards? So it shouldn't be too long. As soon as you get me a draft, I'll go through my notes, comment on it, and we'll send that off. Yeah. Okay.
Yeah, just, I mean, I don't want to create an AOB, but just on that, I mean, I know we've referred back to the President of the Welsh Tribunals on other questions, but shouldn't that go in question 21 as well, on the basis that there is this, that there was a report by the Law Commission about the unification of tribunal. It's been a recommendation from the Council General, it's out for consultation, and the President of Wales will have a view on it. I mean, isn't all that going to supersede the Penn report? Shouldn't we just add that at the bottom in the AOB?
Yes, to emphasise it, yes, it should go in 21 as well then, and we could reference back to the Law Commission thing, which is December 21, and is it the Council General press announcement?
Yes, it was a press.
March, is it?
It's 21st of March. The press announcement from the Council General, Nick Anthony, and now the President.
Yes, exactly.
Shouldn't.
Yeah.
You know.
So actually, that's almost questioning the timing of the whole thing. Actually, that certainly all the APW stuff should be paused. Actually,
I mean, the whole thing really probably should be paused because
the whole thing
of what's going on elsewhere.
Yeah.
I mean, there is a white paper being published. I mean, I've just seen that it is a white paper, so it's not even a green one. So they clearly mean it to happen.
Yeah. So we could put that in question 21 as an emphasis. Yeah. Yes. Yeah, thank you for that. That's very important because in a way, like the whole timing of this comes into question, isn't it? Like you should have paused this until that comes out.
I suspect it's right hand and left hand.
Yes.
This is in a different department of Welsh Government.
Yeah.
And the legislative changes are in a different area. It's in the Council General's office, and the two bits of Welsh Government departments have not. I mean, it's the old age problem of government, really.
Yeah.
One hand not knowing what the other hand's doing, but
anyway, we will make that remark in question 21. Yep. Right. Thank you for that. We're now moving on to agenda item 8, which is a standing item on our agenda, just to make sure that we keep up with any code of conduct training delivered by officers. This means scheduled or requested, because sometimes requests for specific training come in and are carried out, and sometimes you do specific community council training in response to requests. So since February, have you done any code of conduct training either to members or to any community or town council being requested?
There's me logging back in.
Right.
No, the offer has gone out. Actually, thinking more because of new members of various committees, and that's something that we will need to catch up on as well. I haven't delivered any since February, and I will just double check with Ben and Joe.
I haven't delivered any.
I don't think Joe has either. She wants to shout. So no, nothing to update on.
I had a recollection, I may have missed this, sorry. I had a recollection in the last meeting that there was one councillor that had missed the whole thing, and there was an invitation to go out. Do we know if that councillor has picked up that invitation?
So yeah, and we had a by-election as well, of course. So,
right.
So yes, the invitation has gone out, and to pick up some of the new independent members of the Governance and Audit Committee, which I think you'll probably cover.
We'll come on to that because you may have spotted that there's some missing paragraphs on the next item, which is the annual report. And so the training paragraph there, I'm still short of data. And there is this question of what happened to the person who missed the training we went to, and then what's happened to by-election people, and some indies like us on governance and audit as well to deal with. We'll come back to that.
Yeah, okay.
Thanks. Yeah. So that's it for code of conduct training.
Yes, thank you.
Great. Okay, next item, draft standards committee annual report. So this was an action from February standards committee, as you will see in the minutes, to bring a draft here with the aim of it going to council in July. Council in July, because as I'll come on to, in my view, if we haven't got the accurate data from the Ombudsman on conduct and complaints and outcomes for the year just ended 31st of March, there is no point in me producing an annual report until I have that data. So that's the caveat we'll come on to. There's two documents on the agenda. One you've seen before, most of you, nearly all of you, which is the Local Government Act, section 56B, annual reports by standards committees. And I just put that again because that defines in that report. It sets out the structure, which I have followed in the draft. Section 56B comes from the Local Government and Elections Wales Act 2021, section 63. There is also a draft report. The aim is to consider the draft and look at conditional approval going to council, possibly July, possibly later. So if we go to the report, I'll just get it out here. There are three sections in here, which conduct performance data, conduct complaints data, or confirmation, which are, the big one is paragraph 2.5, and every year all Welsh principal authorities receive an annual letter from the Ombudsman which sets out the results of both services complaints, potholes, highways, dog bins, all of that, how many you had, what happened to them, and conduct complaints. And the letter goes to the leader and copied to the chief executive and goes to full council. Is that correct? Usually arrives in August, has been known to be September.
Sorry, the Ombudsman's letter goes to Cabinet.
No.
On these.
Yeah. The annual letter. Yeah. But that's what has the data where the Ombudsman tells us how many complaints about Monmouthshire County councillors or town and community councillors were determined, i.e. they resolved during the year, and what the outcome was and where that fits. And for almost every year since I've been here, we've had a nil report. There's been nothing's ever been forwarded to us. There've been no hearings, and only one year, I think, one but that took place before I joined. So typically, we do very well on the Ombudsman data, and that's really important because that's the overarching, if you like, performance measure of how well are we doing in terms of our role to promote and maintain high standards of conduct. That's in the Local Government Act. That's our primary function. And I put in 2.4, the committee is therefore accountable for the volume and nature and outcome of conduct complaints. I'm not saying there that we are accountable in the sense that if we have a burst of bad behaviour, low-level complaints going to the Ombudsman, stuff going to the adjudication panel, then we could be called to account by council to explain why has that happened? Have we missed something? Have we not had the framework in place? Have we not trained people? So I think the committee is accountable for aggregate complaints, but we're not responsible for individual councillor behaviour, if that makes sense. The second piece that I think is okay, you'll see that I was basically predicting the future, because I said the monitoring officer reported to the committee today that throughout this, etc. That was from a discussion with Matt as how we would handle the issue of informal conduct complaints, because with a complaint about a county councillor, anyone can complain to the Ombudsman, but then they've got the data, which may or may not get back to Matt informally, and comes back in the annual letter. And of course, low-level complaints go to and possibly triggering a thing called the protocol for self-regulation of member conduct, which is basically how should low-level local complaints be resolved locally. And this statement, there have been no matters that have escalated to the point of requiring the instigation of the protocol. It's very important because it basically says, in terms of informal complaints about county councillors, it was a very good year. Is that fair?
As ever.
As ever.
Yeah, I've stated before in this meeting that as this committee is in terms of that reactive position that I set out earlier in terms of conducting hearings, it is fairly high up my priority list to keep you as quiet as possible by dealing with anything in as low a level as possible, ensuring that the relationships are there. So yeah, no, I've not had to go to any group leaders or use the self-regulation protocol. And forgive me, I'm now reading your report off my phone because I couldn't get anything.
Right, fine, that's fine. So basically, you're happy with 2.6. We need to fix 2.5, and that will determine the date at which this goes to council. And then paragraphs or sections 3, 4, 5. 3, 4 and 5 are lifted from the Local Government Act, section 56B. We have to report on that, and you can see it's a nil report. I mean, we had nothing from the Ombudsman, therefore we took no action, and we had nothing from the adjudication panel, therefore we took no action, which is the definition of a good year. So therefore we had no hearings.
Or as they say in the military, undetected crime. But paragraph, I absolutely will not be putting that.
Yes. Okay. So we had no notices regarding member conduct were received from APW, etc. The one thing that I need to straighten out with Matt, which was back to your point, Rhiannon, 6.1, because I was vaguely aware some councillor, unnamed, didn't make the big training at Usk that we 4 independents went to about in May last year, and most of the councillors went to that, didn't they? Then there was a mopping up exercise involving an evening session, I think. So Matt, if you and I perhaps make a comment about, you said something to me about invitation of the 4 indies on governance and audit and where they are. So if we get together and rewrite 6.1 in accordance with that, and the rest of it then is, I read this again, and my conclusion actually is something happily ever since I've been chair is we strongly commend all members of the authority for continuing to maintain high standards of conduct throughout a particularly challenging year. And I think we've said that before, it's new administration with loads of new councillors and the economic environment and the severe budget constraints, I think is really a well done from us actually, because it has been a tough year for elected members, and that's a very good conclusion. And so I might actually switch paragraph 8 and 9, because we have the power to make recommendations to the authority, but it's because of the conclusion about the continuing high standards of conduct that I, as chair, I have no recommendations to make, because I'm happy that the system is in place and is working, and is making the right things over the year, which is in our minutes, etc. I will just say a couple of things about this report that when I was thinking about it, I thought in writing this, I wanted to make it proportionate in the sense that we are actually a very small committee who only met twice in that financial year. So that's probably less than any other committee on the committee list, perhaps the employment committee or something, but we've only got 8 members. We're one short at the moment. To give you an idea, governance and audit in the last year met 9 times. They've got 12 members. So the resource usage and the number of meetings means they need a detailed annual report. But I felt if someone wants to see how we've discharged our functions, I would say we've got 2 sets of very well written minutes which capture all of our actions very well, which we followed. And so that's why this is a proportionate, and it's proportionate given the conclusion, because actually it's like a nil VAT return. Have you ever done one of those? You put 0 in every box and press go. And the government says you have provided a nil return. That's it, and they're happy. Simple headline I've talked about. It's a very high standards in challenging year, and the structure has strictly followed section 56B, i.e. section 63 of LGE 21 to the letter. Although I will reverse the recommendations and the conclusion, because the reason I've got no recommendations is because of the conclusion.
Yeah, that sounds fair.
And the one, just a question first for Matt, is in the legislation, it says something about the authority receiving the report. So it must consider each annual report made by its standards committee before the end of 3 months, beginning with the day on which the authority receives the report. When this goes to council, what actually happens to it? The vote approve it, like they approve a code of conduct change. They just note it, do they?
Yes, it will go with a recommendation to note, because it is your report. It's not a cabinet member report requesting something of council. The debate, the discussion within council, and then actions that fall out of that would form a response. So if the discussion is, thanks very much, we're happy with that, next agenda item, please. Then
that's it.
That there is no response.
Yeah.
If there was something specific, what we would capture in the minutes is there might be an action. I'd always expect an action to lie with the cabinet member or occasional officer. So probably Councillor Sandals given the brief to feed back on behalf of council to standards committee if something came up in the discussion. I'm relatively confident that's probably unlikely given the nature of this report.
Yeah. Okay, so members, do you have any comments or queries on the report, with the caveat that paragraphs 2.5 and 6.1 will be written by me and Matt to get the data accurate, and I will reverse, because I reverse at 8 and 9, because
Yeah.
the reason I've got no recommendation is because of the very positive conclusion. It
Yeah.
makes sense.
Yeah.
Do you have any comments or questions? No, is that okay?
Just by the by, really, the vacancy for the independent member, is that in process of being filled?
No.
That may well be a question that's asked. It looks, the baldness of that sentence in it 2.1 sort of suggests that we're not really too bothered about it at the moment.
Well, we won't, as things are about to change. We may be, yeah. So I left that deliberately. If someone asks me, by the time this goes to council, I'll be able to say something, or officers will be able to make a comment. But there's nothing going on at the moment. I'm heading for the holiday season, and we're not going to meet again till October. So
the legal requirement is the standards committee has to number between 5 and 9. So you're legally sound at 8. Constitutionally, it's written down as 9, but we've actually operated with these numbers for quite a lot of the time for varying reasons.
Yeah. Picked up on, and I'll make sure that by the time this goes, we have a joined up answer between me and officers. Then, yeah, I'll note that. See, okay. Members, so just like to confirm then, members, that you're happy to approve this as it stands, with the amendments to be agreed between me and Matt as monitoring officer on sections 2.5 and 6.1, and the reversal of sections 8 and 9. Any other minor typos, grammatical stuff, and then that will then go to the council, provided, as we have the 5th of July deadline, we get the ombudsman data. That's going to be the key thing, because it is absolutely pointless if we, because we could easily do this and then we get ombudsman data said, I've just sent one of your councillors to the adjudication panel last year. I'm telling you about it now. Hypothetically, we'd hope not. but I don't want to put this out until we've got cast iron. So that's the timing.
Is there any mileage in asking the ombudsman when they're going to issue their letter? Just a polite, courteous note to them.
Yeah,
you have. Right.
Yeah, so
I don't have an answer.
Right. Okay. And I'm very happy for you to make those amends, but just to be absolutely transparent, do you want to send us all the amendments before you finally sign it off?
Yes, sorry, yes, of course.
And give us a tight deadline so we don't leave it sitting in our inbox.
Yeah, exactly.
And if you haven't had a response by then,
it won't be any surprises. The PSOW data will just be in the line of, they produce that one-line table that says, and they produce a one line for members of this authority, and they produce one line for all the town and community councils in the county with the same headings. It'll be those tables with an explanation of what the headings mean, perhaps something like that, and then to say, and hopefully that's another year. And then on the 6.1, we just need to straighten out the numbers and possibly try and make it a bit more specific on numbers and dates.
Yeah.
That's all, particularly with the people that come into it through by-elections and the relatively new independent members on governance.
How many by-elections have we had, Matt?
One.
Oh, one.
Yeah. Okay, I think that's that's done. First of all, so the date of the next meeting is the 9th of October 2023, and then it's the 26th of February 2024. And finally, I need to say thank you very much to Matt for all his support for the committee and for me as chair. Incredibly, nearly 5 years. I clocked back and I thought, when did you I found a picture of you in your military gear in one of the papers from August 2018. Is that right?
Yeah.
And just to say, best wishes in your new role at Cardiff and Vale University Health Board as Director of Corporate Governance. And thank you very much.
No, thank you. And it is partly down to the strength, especially the independent member element of the Standards Committee here, that we get to put reports like the like that you're writing. And thank you especially to you, Richard, because you're engaged not only here but on a national level. The council should probably do well to recognise that. So thank you very much.
Right. Thank you very much. Thank you all. And I now close the meeting at 12:06.